Welcome to Bankruptcy Preference Insights, the program where we explain commercial bankruptcy preference issues in short, concise chunks. I'm Hal Schaeffer, and I've worked on over 850 preference cases, some for the companies being asked to return money and some for the estates. In this session, I'll answer another million-dollar questions. Since I am not an attorney, and not giving legal advice, I'll explain it in layman's terms. Yes, another million-dollar question. It goes something like this. Assuming that I received payments during the 90 days before the bankruptcy was filed, when would I receive either a demand letter or a preference action being filed against my firm? First, bankruptcy preference actions must be filed within 2 years of the filing date for a Chapter 11 reorganization case. If the Chapter 11 reorganization case is converted to a Chapter 7 liquidation case, then the bankruptcy trustee is granted an additional 1 year to file preference actions. In cases where there is not much to be done as far as resolving issues with the bankruptcy, and the case is that of a smaller firm, then it is more likely that the preference actions could be filed far earlier than the 2 year limit or potential near 3 year limit for a converted case. In cases where there is a larger firm involved, but not many preference actions to be filed, demand letters may be sent out to attempt recouping of payments made within the 90 days prior to the bankruptcy filing date. If these demand letters are ignored, the preference actions may be filed after the deadline date that is listed on the demand letter, but there are 2 year they before the 2 year deadline or potential near 3 year limit for a converted case. Finally, when there is a large number of potential preference actions that need to be filled, and the case is is a complex case that is taking much longer to resolve, then these preference actions may be filed immediately prior to the 2 year deadline for filing a preference action or potential near 3 year limit for a converted case, as these preference actions are important to the estate. It does take time to take and get those out. And if you've got a tremendous number of other issues, then you may not have resolved them quick enough to take and get you to that final deadline period in order to file these preference actions. Regardless of the timing of receipt for either the demand letter or the notice of preference action that has been filed against your firm, it is vital that you contact your attorney to address these actions immediately. Well, that's it for today. Please check out our other videos on this channel. And of course, we always appreciate those subscribes, thumbs up, and shares. Thank you very much.